Hey guys, did you know that when you're applying for citizenship, if you have any kind of criminal record, even if it's just a bunch of arrests or it's just one conviction, USCIS officers can deny your application under the catch-all provision of the statute. What that means is a CIS officer can deny it. They have the discretion to deny if a person has a pattern of unlawful conduct or a pattern of other questionable behavior that reflects badly on a person's moral character. You have to prove good moral character in order to win and be granted citizenship. If a person has a criminal history, then it's strongly recommended that he or she should go see an immigration lawyer with criminal experience, like myself, or an immigration lawyer who knows a good criminal lawyer who can do the analysis of that person's criminal history. Generally speaking, when I have a client that has criminal history and they want citizenship, the first thing we're going to do is we're going to do a FOIA. We're going to collect the person's FBI criminal history. I'm in California, so we would request the person's California Department of Justice criminal record. And then we would go down the line. We would request records directly from the courthouse, certified court records. Sometimes we have to request records from the district attorney, from the local sheriff. These are all things that USCIS is going to demand before they grant citizenship. It's not recommended that you do this alone and on your own to save money. You're investing in yourself. So remember, this is a kind of expense that's just once and done. You invest in yourself, you pay for an attorney, and you make sure that you get things done right. So I spoke with someone earlier today in my office who has a criminal history, and he sent me his Department of Justice record, and he'd actually had gotten to the courthouse of one of his cases and provided me a couple of records from that courthouse. And we had gone over his record. He had a conviction for reckless driving. The arrest said DUI, but he ended up getting it reduced down to reckless driving. And that was about, I want to say 9 years ago. The other case, though, was a little bit more problematic. He was arrested, he said, for battery with a cousin, a physical fight. That's a 242, Penal Code 242. And later, he was trying to get into the military. And so with help from his then public defender, they negotiated away from battery, which was a charge of violence. And he pled guilty to something called lewd conduct in public. I know it sounds dirty, but it's not. The thing is that in court, they negotiated with the district attorney and the defense lawyer for a PC 647A, a lewd conduct in public. And so what ended up happening was this charge prevented this potential client of mine from owning any weapons, and that's all the DA cared about. And so they made up out of thin air this potentially sexually related charge that he pled to, even though this was a physical fight with a cousin and had nothing to do with sex or pulling on his wiener. The thing is, lewd conduct in public is a crime of moral turpitude. And if you have that conviction within 5 years of applying for citizenship, you're automatically going to be denied citizenship. Now that charge, the lewd conduct charge, happened, I want to say 17 years ago. So he would think, maybe he's in the clear. But not so fast. And this is why you should speak with a lawyer. You should consult. Because there's a provision under law that we attorneys like to call the catch-all provision. And what happens is, even though you don't automatically get a denial because the case is more than 5 years old, the USCIS officer can look at the person's entire criminal history, and if they think there's a pattern of problematic behavior, if there's a pattern of behavior that shows a lack of respect for the law or criminality, even though there's a bunch of arrests and no convictions, the USCIS officer can use the catch-all provision and deny your citizenship based on your overall history that doesn't look good and that reflects poorly on your moral character. So if you have arrests and convictions, or if you just have arrests and no convictions, you should still consult with an attorney and determine what you should do about the catch-all provision that could be used against you to deny citizenship. They can also use the catch-all to deny for other reasons: not paying child support, not filing or paying your taxes. They have a lot of credibility. If there's a problem with credibility, they don't believe you, left some information out, they can also do it for that reason, for not being forthcoming, for misrepresenting. So officers have a lot of leeway to use this catch-all provision to deny citizenship. And you should be careful if you're going to go it alone, and you might have a couple of black spots on your record and you're concerned. It's a great reason why you want to call a professional to do an analysis of your case.